Good morning, everyone. My name is Barrister Mayowa Oyedokun, and you're welcome to today's Adbond Real Estate Insight. I'll be your facilitator for today, and the topic for today is the land documents, proving title to land. Land documentations are records and documents that concerns ownership, possession, and other rights in law. So we have various rights that you can own in a land. You can be the owner of a land. You can have possession or possessory rights over a land, and you can have another right known as easement, like the Adbond deed of assignment. If you have seen one like that of legacy or country home, you see where we have 648 square meter per plot, and then we say the 600 square meter is for building, and the 48 square meter is for the land. Is for easement, for road, for accessibility within the community. So that's easement. So easement is a right in land that you don't really own the land. It belongs to somebody else, but you have the right to access. You have the right to use that land for a particular purpose. So possessory right is what you get from deed of lease. Let me say tenancy, as we regularly call it. Possessory right is what you get from tenancy. And possessory right is a right that is enforceable in law. That is why even as a tenant, you can sue your landlord, but you don't have to do that. You can sue your landlord if he encroaches into your possession. So for the meantime where you are still in possession of that land, you have the right as a tenant. So we have ownership, we have possession, we have easement and other rights in law. So some documents transfer rights in land. Some documents establish that you have the right to own or the right to use that land. So documents in land is land transactions. Like when you want to buy a land, the first thing people will say is, what document can you show to prove that the land belongs to you? So it is land transaction. Then we have prevention of unlawful transfer of property. If we don't have documents, I can enter any land anywhere, bring anyone here and say, this land belongs to me, I want to sell it, without anything, any legal document to back it up. So we also avoid unnecessary litigation, land fraud, and conflict. You can imagine what we ensure if there is no document to prove any land. I can decide to sell off this building that affects land. So I will be going through this list. So one of the most significant methods for making a claim for land ownership or for proving title to lands are documents. So number one on this list is certificate of occupancy. Certificate of occupancy shows that you have right of occupancy or the right to occupy a land. By virtue of the Land Use Act of 1978, there's no absolute ownership of land for an individual anymore. All lands are invested in the governor of a state, and for the rural lands, they are vested in the local government. So the absolute ownership of land is in the governor, who holds this in trust for the benefit of citizens now. So certificate of occupancy, if you have of occupancy, gives you 99 years. Like we call it lease, even though the land is yours. It's like a lease. It gives you the right to the land for 99 years, which is renewable. So, and we have actual right of occupancy. We have deemed right of occupancy. Deemed right of occupancy are for those who owned this land before 1978. The law deemed them that they have the right to occupy the land. So even when they don't apply for actual certificate of occupancy, the law has provided that they are deemed to be the one that has the right to occupy the land. So all this land that the fathers have owned in those years, when the Land Use Act came into, when it was passed in Nigeria, the law provided by Section 34 that they are deemed as the rightful owner of the land, or the one who has the right to occupy the land. One thing is, people assume that certificate of occupancy is like the most, let me look for how to say it. It's like the best way to prove that you are the owner of a land. But there is a case, Ogunleye and Honi, is a locus classicus case, where someone's certificate of occupancy was revoked. So a certificate of occupancy can only show that this land is owned by you. You can't use it to take a land. Like, let's say Mr. A and Mr. B, they have land in a particular area. So Mr. A's land cover 2 plots. Mr. B's land cover another 2 plots. So maybe out of greed or ignorance or something, Mr. A now encroaches into Mr. B's land and sells to you now. So you, the buyer, you go ahead and you get a certificate of occupancy. If Mr. B rises and then goes to court and his right is established that Mr. A has sold to you what he does not have, your certificate of occupancy can be revoked. So certificate of occupancy is revocable. If you don't have it, you cannot give it. That is the basis of it. You cannot place something on nothing. You must have the land before you can sell it or give it to somebody else. So certificate of occupancy can be revoked if somebody can prove that that land does not belong to you or to the vendor who sold to you. So deed of assignment, land agreement, or deed of conveyance is a document by which we transfer ownership in land. That's the first document that you prepare when you, we have contract of sale. Yes, contract of sale is used when your transaction is not yet complete. So I want to buy a land and I still want to investigate. I want to go and check some things. I want to go to court registry and check whether there are cases on it, but I have interest in this land. So we can start with a contract of sale while I go about my investigation and findings. So, but when it has been finalized, then we move to the deed of assignment or land sale agreement or deed of conveyance, which was used in those days. So the deed of assignment transfer ownership in land to you. So, but deed of assignment, for you to transfer title, must be registered. So in case we are in court and you are presenting a deed of assignment that is not registered, the best thing that that deed can do is to show me that there was a transaction between you and the vendor. It cannot prove your title because that deed is not a registered deed. Only a registered deed can pass title to you in land. So without registration, it is just an evidence of a transaction. That's not, the title does not pass to you. So we have governor consent. Governor consent is for every land transaction by virtue of the Land Use Act that vested all land in a governor. Governor consent must be sought and obtained. But in practice, we do deed of assignment and agreement without obtaining the governor consent yet. But we subject such contracts to governor's consent. That means we recognizes the lordship. Now, the overlord or the lordship of the governor over this land. And then whatever transaction is going on between us, it is subjected to governor consent. And then when you apply for it, in most cases, you get the consent of the governor, except where maybe there is fraud or something involved. Like in cases where you have certificate of occupancy, it is always granted to the first owner now. The person who is buying for, like if I own a land or if I buy a land, if the person does not have a certificate of occupancy, I can apply for a certificate of occupancy as the first person who wants to apply for the certificate of occupancy. So any subsequent buyer of that land from me does not need to apply for a certificate of occupancy. All you need is a governor consent for him to consent to that land now. But in the case where maybe my 99 years have expired and I decide to transfer to you, so we have instances like that where the governor cannot deny consent because you don't have or you did not renew your C of O. So, but for every land transaction, governor consent must be sought and obtained. So we have deed of lease and sublease. So deed of lease is when you are doing above 3 years lease. But for the normal yearly rents that we do, we call it tenancy. So it actually gives possessory rights, not ownership rights. Give you possessory rights, and it can be protected under the law. Like I say, you can encroach into my apartment. Let me say my apartment, my house where I'm living as a tenant, and I can sue you for it, including the landlord, because you encroach into my possession. So we have deed of mortgage and deed of release. For deed of mortgage, it is a mortgage is like a property being used as a security for a loan. So by that deed of mortgage, I'm transferring my interest in that land to the mortgagee, the person who is lending me the money now. So, and that establishes you. It gives you a level of rights, equitable or legal rights in that land. So deed of release, after I've paid my money fully, because normally a deed of mortgage is a registrable document. So it can be registered with the government in land registry. So after I've paid my money fully, I'm released from the debt I owe you. A deed of release also had to be prepared to show that this land is no longer under the mortgage transaction. So whoever wants to buy can buy, there's no encumbrance. Then we have survey plan. Survey plan is very, very important in every land transaction. It shows us the boundary of the land, the measurement of the land, the description of the land. Although we have different types of survey plan, but generally you see, survey plan is a legal document. It's established by the law. And according to section 1 of that survey law, it's only a licensed surveyor that should prepare a survey plan. If it is not signed and sealed by a licensed surveyor and not registered, that is with the office of the surveyor general, it is to not become a legal document. It can be maybe just a provisional survey plan. But once it is registered, signed by a licensed surveyor, it becomes a legal document. So it establishes the boundary, it gives us the description, the topography. Like we have different types, like I said, they can give you topography, like are there valleys, are there hills, are there rivers beside the land. So we have excise. Excise is a document that shows that a land that was previously under government acquisition has been released to a community. So the community have the right to the use of the land because the government has, so it is no longer a government land, it is now land belonging to maybe a community or an individual. So deed of assent. Deed of assent is used for the estate of a late person. Let me say Mr. A has died. In his will, he gave Mr. B a land. Mr. B does not automatically come into ownership of that land because his name was written in the will until the administrators of the will prepare a deed of assent and pass it across to Mr. B. So deed of assent are used for passing properties that is given under a will to the beneficiary of the property. Okay. So there is a case, 5 ways of proving title to land. We call it Idundu and Okumagba. It's another low-cost classical case in land, ownership of land. So the first one, like we have spoken about, is production of title documents. Document, generally, any form of document that can show that this land belongs to me. And I said, if a land is not registered, it will not give you title. It can only be an evidence of transaction in the court of law. So the second one is traditional evidence. Traditional evidence is only useful when there are court cases. Traditional evidence must show you an open record of the land. Call it first settlers, like who came into possession of this land in those days. Fought and conquer land, they will say this land belongs to our forefathers. We don't use it when you're buying land because they have to give you unbroken record. Like if they say this land became ours in 1800, they have to show you how from 1800 it passed from one generation one to another without. So it's normally used in land cases in court. So because when you want to buy land, you won't tell them to tell you how the land passed from their generation to their generation. We have various acts consistent with ownership. So as the owner of a land, there are things that you can do with your land. So if there's a case in court that wants to show that this land is actually mine, you can show that by presenting document that shows that, oh, I've been selling this land to people, I've let it out to people in rent, I've given it out to people for farming over time. So that is another way to show that, oh, this land actually belongs to me. And all this will come into play where there are no documents. So the most important thing is the documents. All these other ways can only be used where you don't have any document to prove your ownership of the land. So we have out of long possession and enjoyment of land. And then we have a proof of possession of adjacent land. I think this is just about possession, the 4th and the 5th one. And possession is very important after document. Whether there is document or no document, especially where there are no documents, possession is very important in determining ownership. If you allow somebody to continue using your land for a long time without you taking any step to protect it, eventually they can take over the land from you. And then there's a presumption in law that says that if you own a land, there's a probability you own the adjacent land. So if nobody can present a document to show that this land actually belongs to me, and this person he owns a plot, he moved to the next place, started farming on it, he continues using it, you as the owner, you did not take any step to, protect your property, the land can become theirs when there are no documents for you to prove that the land does not belong to them. So we have registration of land, effect of registering your documents. An unregistered document is just evidence of transaction. It will not give you title, to not protect your title. When you register your documents, you have priority in case there's dispute over the land, over somebody who did not register their own documents. So we have security against land grabbers, as we have seen land grabbers law in Lagos because of the activities of Omonile and all that. Then we have a case of compulsory acquisition of land. When the government, according to the Constitution of Nigeria, government can take over any land for public purpose. So if they decide to take over a land that is yours and there's no document for you, registered document, to show that the land actually belongs to me, you might not be able to get your compensation from the government. So collateral for loan, in most cases, you can't just say I have a land. There must be a document for when you're getting loan from banks to show that I have a land. Then increase in value. As you register your land, get seal of over it, all these documents increases the value of the land over time. So we have precise description of land. I think that's basically about the survey plan now. It helps you to know that this is where the location of the land is. This is what is beside the land. This is, maybe there's a river there, is here an uphill land or so. Then we have only registered document that can be used to prove title in litigation. I've said that over and over. Without registration, you only have a transaction, you don't have a title in land. So various acts of ownership that you can carry out on your land to prove that it belongs to you. I think there are known things. Selling the land, you lease it out or rent, and then you give it out to people to farm on it. Like I will always advise my own clients that buy land. So if you are not using that land at present, if you don't have anything to do with it, and as long as it's not a bush that nobody can access, you can lease it out to anybody. Even if it's for free, the person can farm on it. So to protect your title. So if anybody just coming to say the land belongs to me. So this numerous and positive act, or this act of selling and farming over a long time, like I said, can be used to establish title where there are no documents. So it is dangerous for you to allow somebody to continue using your land without you maybe preparing the documents to evidence that the land belongs to you or that you gave them to use over time. Because if they use it for long enough, they can use it to establish ownership in case of dispute. So, okay, possession of adjacent land. I've also spoken about that. That if Mr. A owns a land and there are lands around him, and they continue extended his use to the lands around him, and the owner did not take any step to at least put him in check, and there are probable circumstances that may make it look like, okay, this person has used this land for 10 years, and nobody has ever intercepted him. And people are even around that area have said, we know the land belongs to Mr. So-so. He has been farming on it. We know he's the owner of the land. So you as the rightful owner of that land, you can lose that land when you don't have documents. Like I said earlier, where there are no documents, it becomes difficult for you to prove land. So the best form of your proving title is the documents. Every other ways of proving documents, ownership of the possession, or various sort of ownership comes into play where there are no documents. So the law aids the vigilant and not the indolent. Where your land is being encroached upon, the best thing to do is to act on time. When somebody has taken possession of a land that is yours, the best thing to do is to put that person in check, or to prepare a document to evidence that permits this person to continue using my land. Because failure to do so over time, if the person continues using your land without any document for you to prove, you might lose your land. Thank you for listening. If you have any questions, you have any comments, you've learned something new, you can drop it. You can ask your questions.